Welcome back, everybody, to our studies in family law. We are continuing talking about familial relationships and continuing talking about marriage, one of the most important of these legal relationships that exists within this particular area. Now, if we remember back to a previous lesson that we did on the subject of marriage, we elucidated the definition of marriage in the case of Hyde and Hyde. We noted in that definition that was elucidated that there is one key element to the concept of marriage that we've yet to focus on. This is the idea of marriage having a temporal element, okay? So taking place over a particular length of time. Lord Penzance noted that marriage is something that takes place as a union between a man and a woman for life, okay? And we've focused on the tricky issue of being between a man and a woman and how that law has changed and is continuing to change over time. But this lesson is going to look at this second part, the part that I have sort of italicized there, which is the idea that there is a temporal permanence of marriage. So the extent to which marriage has to be for life in order for it to be a valid marriage. Now, you can understand why the sort of traditional elucidation of marriage, or even the intent of the parties who get married, intend for it to be a union for life. Most people probably don't get married with the intention that they're going to one day divorce or nullify that marriage. That is something that tends to happen as time goes on and as circumstances change and as marriage and relationships break down. So the lesson here that we're going to look at is really speaking about the temporal permanence of marriage and the extent to which it may be for life. And I've written spoilers that it isn't. You probably, if you're somebody who has lived in the world, know that marriage is not something that has to take place for life, as Henry VIII famously worked out. So let's think about this then. Let's think about this more from a legalistic perspective. Marriage for life, which is something that Lord Penzance noted in that definition in Hyde versus Hyde. The concept of marriage for life will be subject to a number of exceptions in the law today. A marriage can be ended through a number of different means, and we're going to look at these means in more detail in future lessons. But the easiest, of course, is if somebody dies. If one of the people if you married an individual and the person that you married tragically dies, eventually that will happen for everybody, then this will end the marriage. You're not still married to that person. You become a widow. You become widowed. In addition, a marriage could end any other way before the person or one of the peoples in question dies. So it can either end by way of a degree of nullity or even through the imposition of a divorce. Now, like I've said, and like I said in the first lesson on family law, and like I'm going to be focusing on over the next few lessons, the legal provisions for nullity and for divorce and the subject requirements and sort of some cases that we're going to look at will be the subject of other topics in the future. I don't want to get into it in too much detail here. But fundamentally then, what we see here is that this sort of provision within the definition of a marriage taking place between a man and a woman for life is somewhat tricky to reconcile with the actual legal reality. The legal reality is that marriage is not for life because an individual could die, which could end the marriage. You could get a nullification of the marriage. You can get a divorce of the marriage, and a divorce from the marriage. And so the result of that means that the sort of for life part of the definition is also as tricky as the between a man and a woman part of the definition. So how then can we reconcile the concept of marriage being a union for life if there are quite substantial and in some cases quite easy opportunities for marriage to end before the death of one of the parties? We could probably all come to the conclusion that a marriage for life is perfectly reasonable in the context of which a marriage could also end when someone dies. It's not exactly their fault if they die, in most situations at least. And so for that circumstance, we can understand why that would still render a marriage for life and render that concept still meaningful. But what about the other concepts? What about nullity and divorce? How is it that we can say, well, this is a marriage for life if you can quite easily decide to get a divorce or to nullify the marriage? Well, the validity of the marriage could still be justified on the basis that at the time at which the marriage is done, at the time at which the marriage ceremony is done and the sort of legalistic parts of the marriage are performed, there was an intention on the part of the parties for the marriage to be for life. So at the point at which you are standing at the altar, shall we say, and you are getting married, you're going through the process of getting married, there is probably not a single person who is intending for that marriage to not last forever. The idea of marriage and the intention of marriage at the point at which the marriage is performed is something that happens with the intent for it to be for life. And this is actually the key test. If the parties intended for the marriage to be for life at the point at which they had gotten into the marriage itself, then this will essentially validate this part of the definition. This validates the part of the definition, the for life part of the definition. So long as the parties to the marriage had intended for the marriage to be for life, then the validity of the marriage will be guaranteed despite the parties wishing to end that marriage early, through divorce, for example. Of course, this recognizes the change in circumstances that pertains to the concept of marriage, such that even if you intended for the marriage to be for life at the point at which you got married, there are at least changes in circumstances when it comes to life going through the sort of the ebbs and flows of life, and eventually relationships break down, or maybe people get into relationships and get married a bit too early, and then they break down as a result of that as well, or they get married for unsavory reasons, or for reasons that probably aren't particularly good reasons to get married, all of which, of course, recognizes these changes in circumstances. A good useful illustration of this is the case of Nachimson versus Nachimson from 1930. What this case does is illustrate the point that marriage intention is very important for marriage validity. The case itself concerns a couple who had been married in the previously existing Soviet Union. Now, the pair had gotten married in Moscow in 1924. And under the law of the Soviet Union, under Soviet law, there was an option for one of the parties to end the marriage by way of a simple notice. This was a much easier way to end the marriage than that was recognized in English law at the time. If you want to know more about law in the Soviet Union, there's a very good book by John Quigley on legal innovations within the law of the Soviet Union. It's quite interesting and quite insightful in many different ways. In 1929, one of the parties made the decision to issue a notice to end the marriage. So they wanted to end the marriage, and they sought to do so under the basic option of Soviet law, which required only a simple notice. The question for the English Court of Appeal was whether or not the marriage was valid in the first place, owing to the simplicity in being able to end it. Does the simplicity of being able to end the marriage by way of simply sending a notice invalidate the sort of legal standard that is required for a marriage within English law? Well, the Court of Appeal held that, even though the ending of the marriage was simple under this old Soviet law, the key implication for marriage is whether or not the parties, at the point of the marriage, in Moscow in 1924, when they were at the altar getting married, or whatever they had in Moscow. They could have had an altar, in fairness, given that Russia was that Russia was an Orthodox Christian country. Whether or not they were intending for that marriage to be for life. That is the key test. Not whether or not it is simple to end a marriage, but whether or not at the point at which they were looking to get married, and at the point at which they were standing at the altar getting married, did they intend for that to be a lifelong partnership? If the answer is yes, then the marriage is valid, regardless of whether or not there was a simple way of ending that marriage under the law of the Soviet Union, under Soviet law. If not, if they did not intend for that marriage to be for life, then the marriage would be considered invalid.